Good morning, friends. My today's topic is Order 4 Supreme Court Rules 2013. It's at Order 4, Rule 1 says that subject to the provision of the rules, an advocate whose name is entered on the roll of any state bar council maintained under the Advocate Act 1961 as amended shall be entitled to appear before the court. Court means Supreme Court of India. Provided that an advocate whose name is entered on the roll of any state bar council maintained under the Advocate Act for less than 1 year shall be entitled to mention matters in court for limited purpose of asking for time, date, adjournment, and similar such orders, what shall not be entitled to address the court for the purpose of an effective hearing. Provided further that the court may, if it think desirable to do so, for any reason, permit any person to appear and address the court in a particular case. It further says, no advocate other than the advocate on record for a party shall appear, plead, and address the court in a matter, unless he is instructed by the advocate on record or permitted by the court. Further, in petitions, appeals received from jail or a matter filed by a party in person or where a party in person is respondent is not represented by an advocate on record, the Secretary General or Registrar may require the Supreme Court Legal Service Committee to assign an advocate who may assist the court on behalf of such person. Provided that whenever a party wants to appear and argue the case in person, she shall first file an application along with the petition seeking permission to appear and argue in person. The application shall indicate reason as to why he or she cannot engage an advocate and want to appear and argue in person. And if he is willing to accept an advocate who can be appointed for him by the court, such application shall in the first instance be placed before the concerned registrar to interact with the party in person and give opinion by a way of office report whether the party in person will be able to give necessary assistance to the court for proper disposal of the matter, or an advocate may be appointed as amici curiae. If the application is allowed by the court, then only the party in person will be permitted to appear and argue the case in person. Provided further that whenever an advocate whose name is entered on the roll of any state bar council mentioned under the Advocate Act want to appear and argue the case in person, he shall be exempted from the requirement of interaction by the concerned registrar. So, up to this, the conclusion is if an advocate is having less than 1 year experience, he can appear before the court either with the permission of the court or with the permission of advocate on record for simple things, just as for requesting for adjournment, very simple, but he cannot argue. But the advocates who are having experience more than 1 year, and if their advocate on record allows them to appear and argue the case, they can do so. Further, where the party is appearing in person, then the registrar is duty bound to assess whether the party will fruitfully place his case, argue his case. If he is satisfied, he will send a report that the party can do so. But as far as sometimes advocates uh, want to appear in their own personal case, then in those cases, this permission of the registrar is not, no interaction with the registrar is required. He, with the permission of the court, can appear. Now, going further, the Chief Justice and the judges may, with the consent of the advocate, designate an advocate as senior advocate if, in their opinion, by virtue of his ability, standing at the bar, or special knowledge or experience in law, the said advocate is deserving of such distinction. So there are so many intelligent with sharp you can say IQ, and if they are recommended and he has permitted to do so, they can be designated as senior advocate. It all depends upon the quality of a advocate. But once he is designated an senior advocate, then his duties changes. A senior advocate shall not file a wakaltnama or act in any court or tribunal in India. A senior advocate now shall not appear without an advocate on record in the court or without a junior in any other court or tribunal in India. And a senior advocate shall not accept instructions to draft pleadings or affidavit or advise on affidavit evidence or to do any drafting work of an analyst kind in any court or tribunal in India or undertake convincing work of any kind whatsoever, but this prohibition shall not extend to settling any such matter as aforesaid in consultation with the junior. Further, a senior advocate shall not accept directly from the client any brief or instruction to appear in any court or tribunal in India. So, after being designated senior advocate, his duties are in restricted mode. He cannot appear before the court without the advocate on record. Advocate on record is given more preference as far as filing is concerned and other activities are concerned. As the Honorable Court is directly connected with that advocate on record to get all type of formalities for the smooth running of the justice system. His presence is mostly needed. Now, what mean by acting? It has been defined under Order 4. Acting means filing an appearance or any pleading or application in any court or tribunal in India, or any act other than pleading, required or authorized by law to be done by a party in such court or tribunal, either in person or by his recognized agent or by an advocate or attorney on his behalf. Now, they had also defined tribunal. Tribunal will include any authority or person legally authorized to take evidence and before whom advocates are, by or under any law, for the time being in force, entitled to practice. Here they love what do it is junior in this Order 4. Junior means an advocate other than senior advocate. Upon an advocate being designated as a senior advocate, what are the duties of the registrar? These are explained here. Registrar shall communicate to all the high courts and the Secretary to the Bar Council of India, Secretary of the State Bar Council concerned the name of said advocate, and date on which he was so designated. Every advocate appearing before the court shall bear such robes and costume or as may from time to time be directed by the court. Any advocate not being a senior advocate may, on his fulfilling the conditions as laid down earlier, be registered in the court as an advocate on record. Well, whatsoever is the qualification is shown in Rule 5. I am reading out how one can become an advocate on record. No advocate shall be qualified to be registered as an advocate on record unless what formality he had to, compulsory formality he had to require to do. His name is and has been borne on the roll of any state bar council for a period of not less than 4 years on the date of commencement of his training as provided hereinafter. Provided, however, if any candidate has earlier appeared in any of the advocate on record examination, he shall continue to be so eligible to sit in any subsequent examination of the advocate on record. Second condition is he has undergone training for 1 year with an advocate on record approved by the court and has thereafter passed such tests as may be held by the court for advocates who apply to be registered as advocate on record. Particulars whereof shall be notified in the official gazette from time to time, provided, however, that an attorney shall be exempted from such training and test. They need not to do so. A solicitor on the rolls of the Bombay Incorporated Law Society shall be exempted from such training and test if her name is and has been born on the roll of the State Bar Council for a period of not less than 7 years on the date of making the application for registration as an advocate on record. The Chief Justice may, in appropriate cases, grant exemption for what? For these things. From the requirement of training under this clause in the case of an advocate whose name is borne on the roll of any state bar council and has been borne on such roll for a period of not less than 10 years. From the requirement of clause 1 and from training under his clause in the case of an advocate having special knowledge or experience in law. The Honorable Chief Justice has the power to do so. After he has cleared all the examinations, gone through the procedure, he has an office in Delhi within a radius of 16 kilometers from the courthouse and gives an undertaking to employ within 1 month of his being registered as an advocate, a registered clerk. This is compulsory clause. And he will have to pay registration charges, that is 250 only. Then an advocate, he has been convicted of an offense involving moral turpitude, shall not be eligible unless the said conviction has been stayed or suspended by any court to appear in the tests referred above. On and from the date of such conviction and thereafter for a period of 2 years. With effect from the date he has served out the sentence or has paid the fine imposed on him or has served out the sentence and paid the fine imposed on him as the case may be. Provided that the Chief Justice may, if he thinks fit to do so, relax the provision of this rule in any particular case or cases. The Honorable Chief Justice, having lot of powers to give relief in every circumstance. It further says nothing in clause 1 shall apply to an advocate who has been released on probation of good conduct or after due admonition, and no penalty has been imposed thereafter in the manner provided under the provisions of Protection of Offenders Act 1958 or under Section 360 of the Code of Criminal Procedure 1973. An advocate on record shall, on his filing a memorandum of appearance on behalf of party accompanied by Bakalatnama duly executed by the party, be entitled to, when he receives a Bakalatnama duly executed by the party, he can do to act as well as to plead for the party in the matter and to conduct and prosecute before the court all proceedings that may be taken in respect of the said matter or any application connected with the same or any decree or order passed therein, including proceedings in taxation and applications for you. All work he can do whatsoever related to the case. And he can receive money, deposit money on behalf of the said party. Where the Bekaltanama is executed in the presence of the advocate on record, he shall certify that it was executed in his presence. Where the advocate on record merely accepts the Bekaltanama, which is already duly executed in the presence of notary or an advocate, he shall make an endorsement thereon that he has satisfied himself about the due execution of the Bekaltanama. No advocate other than an advocate on record shall be entitled to file an appearance or act for the party in the court. Every advocate on record shall keep such books of accounts as may be necessary to show and distinguish in connection with his practice as an advocate on record. Money received from or on account of and the money paid to or on account of each of his clients. All money is received and money is paid on his own account. Every advocate on record shall, before taxation of the bill of costs, file with the taxing officer a certificate showing the amount of fee paid to him or agree to be paid to him by his client. Where an advocate on record ceases to have an office or a registered clerk or both as required above, notice shall issue to such an advocate to show cause before the chamber judge on the date fixed why his name should not be struck off from the register of advocate on record. And if the chamber judge makes such an order, the name of such advocate shall be removed from the register accordingly, and advocate shall thereafter cease to be entitled to act as an advocate on record. Where an advocate on record is suspended or his name is removed from the state roll maintained under the Advocate Act 1961, he shall, unless otherwise ordered by the court, be deemed as from the date of order of State Bar Council or Bar Council of India, as the case may, to be suspended or moved from the register of advocate on record for the same period as is mentioned in the order of the State Bar Council or Bar Council of India, as the case may be. When on the complaint of any person or otherwise, the court is of the opinion that an advocate or court has been guilty of misconduct or of conduct unbecoming of an advocate or court, the court may make an order removing his name from the register of advocate on record either permanently or for such period as the court may think fit and the registrar shall thereupon report the said fact to the Bar Council of India and to the State Bar Council concerned. Provided that the court shall, before making such order, issue to such advocate on record a summons returnable before the court or before a special bench to be constituted by the Chief Justice, requiring the advocate or court to show cause against the matters alleged in the summons, and summons shall, if practicable, be served personally upon him with copies of any affidavit or statement before the court at the time of issue of the summons. For the purpose of these rules, misconduct or conduct unbecoming of an advocate on record shall include mere name lending by an advocate on record without any further participation in the proceeding of the case. This was happening earlier, but now it is controlled one. And there are two other situations which has been actually put on hold. But there is written in the provision, so I am reading out. Absence of the advocate on court from the court without any justifiable cause when the case is taken up for hearing, and failure to submit appearance slip duly signed by the advocate on record of actual appearance in the court. Any advocate on record may at any time by a letter request to the registrar to remove his name from the register of advocates on record, absolutely or subject to his continuing to act as advocate on record in respect of all or any of the pending cases in which he may have filed a wakalatnama, of which he shall file a list. The registrar shall thereupon remove his name from the register of advocates on record absolutely or subject to as above said. Every advocate on record shall notify to the registrar his her email address and address of his office in Delhi, and every change of such address and any notice, writ, summons, or other document sent on such email address or served on him or his clerk at the address so notified by him shall be deemed to have been properly served. An advocate on record or firm of advocates may employ one or more clerks to attend the registry for presenting or receiving any papers on behalf of the said advocate or firm of advocates, provided that the clerk has been registered with the registrar on an application in the prescribed form made to the registrar for the purpose. Provided further that the said clerk gives an undertaking that he shall attend the registry regularly. Notice of every application for the registration of clerk shall be given to the Secretary, Supreme Court Bar Association, who shall be entitled to bring to the notice of the registrar within 7 days of receipt of the notice any fact which, in his opinion, may have a bearing on the suitability of the clerk to be registered. The registrar may decline to register any clerk who, in his opinion, is not sufficiently qualified or is otherwise unsuitable to be registered as such, and may, for reason to be recorded in writing, remove from the register the name of any clerk after giving him and the employer an opportunity to show cause against such removal. Intimation shall be given to the Secretary, Bar Association, of every order registering a clerk or removing a clerk from the register. Every clerk shall, upon registration, be given an identity card which he shall produce whenever required, and which he shall surrender when he ceases to be the clerk of the advocate or firm of advocates for whom he was registered. Where a fresh identity card is required in substitution of one that is lost or damaged, a fee of 50 rupees shall be levied for the issue of same. Every advocate on record shall have a registered clerk. No advocate may employ as clerk any person who is taught. The registrar shall publish list of persons proved to his satisfaction by evidence of general repute or otherwise, habitually to act as tout to be known as list of tout, and may from time to time alter and amend such list. A copy of every list of tout shall be displayed on the notice board of the court. Now, what mean by tout? Tout means a person who procures in consideration of any remuneration moving from any advocate or from any person acting on his behalf the employment of such advocate in any legal business, or who proposes to or procures any advocate in consideration of any remuneration moving from such advocate or from any person acting on his behalf the employment of the advocate in such business, or who, for purpose of such procurement, frequents the precincts of the court, then he will be treated as tout. The passing of regulation by the Supreme Court Bar Association or by High Court Bar Association declaring any person to be tout shall be evidence of general repute of such person for the purpose of this rule. No person shall be included in the list of touts unless he has been given an opportunity to show cause against the inclusion of his name in such list. Any person may appeal to the chamber judge against the order of the registrar, including his name in such bar. The registrar may, by general or special order, exclude from the precincts of the court all such persons whose names are included in the list of touts. No person, the registry may, no person having an advocate on record shall file a wakalatnama authorizing any another advocate on record to act for him in the same case, save with the consent of former advocate on record, or by leave of the judge in chambers, unless the former advocate on record is dead or is unable by reason of infirmity of mind or body to continue to act. Where a party changes his advocate on record, the new advocate on record shall give notice of the change to all other parties appearing. No advocate on record may, without the leave of the court, withdraw from the conduct of any case by reason only of non-payment of fees by the client. An advocate on record who, on being designated as a senior advocate or being appointed as a judge or for any other reason ceases to be an advocate on record for any party in a case shall forthwith inform the party concerned that he has ceased to represent the said party and as an advocate on record in the case. The senior advocate so designated shall not appear as senior advocate till he reports to the registry that parties represented by him earlier have been so informed of his designation as senior advocate and that necessary arrangements have been made for the parties to make appearance before the court in all the cases represented by him till then. No party having an advocate on record shall be heard in person save by the special leave of the court. No advocate on record shall authorize any person whatsoever except another advocate on record to act for him in any case. Every advocate on record shall be personally liable to the court for the due payment of all fees and charges payable to the court. Two or more advocates on record may enter into partnership with each other, and any partner may act in the name of the partnership provided that the partnership is registered with the registrar. Any change in the composition of the partnership shall be notified to the registrar. Two or more advocates not being senior advocates or advocates on record, may enter into partnership and subject to the provisions contained above. Any one of them may appear in any cause or matter before the court in the name of partnership. This was all about Order 4. It contains up to rule 20, it contains 23 rules. So it was a lengthier one. Enjoy your day. God bless you all.